All right, hello and welcome to another episode of A Fresh Perspective with Jeff Charles, with your favorite conservatarian, Jeff Charles, where we prefer, you know what, we prefer truth over narrative and principles over politics. And I've got yet another fire conversation for you today. We're going to talk about the Supreme Court and some of the cases that they've got in front of them. I know which one you're already thinking of, but we're going to talk about that and also one other that is also important. But before we get into all of that, you know what you got to do. You got to like this video. You got to share this video. And you got to subscribe to my channel. Whether you're watching this on YouTube or you're listening to this on your favorite podcast app, you need to subscribe if you haven't already. That way you'll be notified whenever I upload a new interview or a new podcast, which comes out every Wednesday and Friday evening at 7 o'clock Eastern Standard. Also, if you want to support my work monetarily, you got all the apps in the show notes here, the CashApp and the Venmo app and all that great stuff. I appreciate everything. Also, remember that LibertyNation.com is a proud sponsor of A Fresh Perspective. Check out LibertyNation.com for all of your conservatarian news, original articles and analysis, videos, podcasts, Liberty Nation Radio, and their signature TV program, The Conservative Five, all on LibertyNation.com, where truth is making a comeback. Now, without further ado, I would like to bring on my guest here and introduce you to the Associate Professor at Notre Dame Law School, Sherif Girgis. How you doing, brother?
Good. Thanks for having me.
Good. I'm glad that you were able to make it. I'm very excited about this conversation. It's weird because I don't normally cover Supreme Court stuff, but lately I've been a lot more excited about it because we're kind of in an exciting time right now.
We are.
Yeah, definitely. So before we get into all that, why don't you tell us a little bit about yourself?
Yeah, I'm, as you mentioned, just started teaching at Notre Dame Law School. Before that, I was clerking for Justice Alito and for a judge on the D.C. Circuit, Tom Griffith, and I was in private practice for a while in D.C.
Oh, okay. Yeah, I didn't realize that you had clerked for Alito. His name has been in the news a lot recently. For some reason.
Yeah, it seems.
I can't imagine why.
Exactly.
So why don't we get into it? Roe v. Wade. Now, here's my question. First off, before I even get into that, when are they actually going to issue the ruling? Because they're talking about, they might issue it on Monday or whatever. Are they just trying to keep us guessing? Are they doing like a Donald Trump kind of thing where they want to like keep us on edge? What's going on here?
Yeah. So in general, the justices have said this publicly a lot of times, and at first I thought it couldn't be true, but it is. Which is just they release them when they're ready. So it tends to be that the biggest deal cases get released towards the end, just because people are tinkering with their opinions more in those kinds of cases. But I suspect that, the Chief Justice in his statement about the leak, which I'm sure we'll get to, said this isn't going to change our operating procedure in this case at all. And I suspect that's right.
Yeah, when I did see headlines indicating that they could release a ruling like yesterday, I was like, I don't know about that, because like you said, they want to make sure that this is going to be on the record for the rest of eternity. So yeah, they want to make sure that they get everything exactly the way they want it. And I know they have until the end of June to issue the ruling, right?
Yeah, they don't have any formal deadline. They almost always finish by the end of June. Sometimes they go a few days into July, but they jealously guard their summer break. So I don't expect that, no matter how high the stakes are, I don't think they'll take too much longer.
Yeah, I would guard my summer breaks too if I were them. So when it comes to the whole leak thing, I mean, first off, in your experience, when it comes to Roe v. Wade, I've seen that there are a lot of misconceptions. They think that if it's overturned, then abortion is outlawed. But really, all it means is that it goes to the states. Do you think that most people know that, or do you think that most people think that it's going to eliminate abortion?
I think most people don't understand that. So you're right. First of all, if Roe v. Wade is overturned, that only means that states get to do whatever they want on abortion law. So New York and California are going to double down and make sure that it's publicly funded and accessible at all stages, and maybe they'll even ship people in from out of state. And then other states will be more restrictive, obviously. So I think people don't understand that. And another thing they don't understand is how aggressive Roe v. Wade's limits on the states are. Because in the same polls where people say they're in favor of Roe v. Wade, they also say they're in favor of abortion restrictions that Roe v. Wade says you can't have.
Okay. Now, can you give us an example of some of those restrictions?
Sure. Yeah. So one thing that's clear in Roe and the follow-on case, Planned Parenthood versus Casey, is that a state is not allowed to ban abortions until at any point before viability, and viability is around 22 to 24 weeks. So pretty strong majorities of Americans support a ban from 12 weeks onward. And 24 weeks is obviously twice as long as that. So that's just one example of the kind of law that most people, even people who aren't sort of at one end of the spectrum or the other, think is a sensible policy that Roe says is unconstitutional.
So if Roe, or if it forbids it before 22 weeks, how was Texas able to pass their heartbeat law, which I believe was 15 weeks?
It's earlier than that. It was 6 weeks. So it's interesting because Texas says that the Texas law says there's a defense. If you get sued under this Texas law, you can plead as a defense that the abortion that you helped out with was the person was entitled to get under Roe and Casey. So its scope was always unclear. The main reason that it ended up deterring a lot of abortions is that people found for complicated legal reasons, it was hard to get a federal court to strike it down before anyone had tried to enforce it. So nobody wanted to be the first one to violate it and then risk having a court system say, actually, the law's okay because we're about to overturn Roe. That was the main issue there.
Okay, so they possibly could have challenged it, but they decided not to because they could be like a Pyrrhic victory, like it would be one where they win.
So sometimes, it's two things. One, that to some extent, but the other thing is that a lot of times you get to challenge a law before anyone has ever tried to enforce it. So if there's a restriction on your speech, you don't have to violate that law and then come in and say, hey, but my speech was protected under the Constitution. Right. You get to ahead of time come into court and say, I want to violate this law, and I think it's unconstitutional. Can you say so that I can then have my speech? For weird legal and procedural reasons, the Texas law was designed in a way that makes it harder for courts to strike it down before anyone has ever tried to enforce it. So
I see.
So then, in order to get a challenge going in federal court, at least, you would have to violate the law. And the law, by the way, doesn't penalize the women who seek abortions. It penalizes the women who help them, the people who help them.
Yes.
So you don't want to be the Uber driver who drives somebody to go get an abortion and then gets slapped with a $10,000 lawsuit and then has to hope that the Supreme Court somehow sticks to Roe v. Wade when that lawsuit goes all the way up the chain. That was the issue.
Yeah, and I would imagine that it would be hard to enforce anyway. I mean, if you are that Uber driver, first off, I mean, there has to be somebody who witnesses it, knows that you helped do it, knows that you possibly, because you could drive somebody to the whatever and not know what they're going to do. And it just seems like it would have been really almost impossible to enforce anyway. So
right, exactly.
Yeah. So if Roe v. Wade is overturned, what position does this put Democrats in, or the pro-abortion crowd? Like, what recourse would they have as far as either challenging that decision, or I know they tried to codify it into law. Do you have to?
Sorry, I need to send a 4-year-old out the room.
That's okay.
And I'm back. Sorry about that.
Yeah, thoughts on this too. That's fine.
Yeah, that's right. This is the perils of a home office. So I think that, everybody, it's a situation neither party has been in before. That for the first time, they're not just going to talk about abortion and state their position. They actually have an opportunity to change the rules. So on the right, you're going to have people who are, I know you're asking mainly about the left, but on the right, you'll have pro-life people lawmakers who've said they're pro-life, who now actually have to put their money where their mouth is and decide when am I going to vote for a ban, from what stage, and so on. And then people on the left will only lose if Roe v. Wade is overturned because the court has required their favored policy. So now they'll have to defend it on the merits, and you'll see two sets of things. You'll see people trying to defend the kind of capacious abortion access that they promote. And then you also, I think, see the federal government, the Biden administration, trying to find ways to override state restrictions or help people get around them.
Okay. So they did try to codify Roe into law, or actually they went beyond it in the Senate. And obviously that tanked. But in the future, like say if in the future they manage to retake control of Congress, because they're probably going to lose it in November, and would it be possible for them to pass legislation similar to what they already tried, or maybe like a watered down version of it? Would that also work, or would that supersede what the Supreme Court does, or how does that work?
Yeah, so if Dobbs comes out the way it looks, all it says is states don't have to allow abortions. It doesn't immediately speak to what Congress can or can't do or anything like that. So then the question is, all right, maybe there's no constitutional right, but can there be a federal statute that guarantees it, basically by overriding state laws? There are lots of different areas where the federal law overrides any contrary state laws, and can this be one of them? The main question at that point will be whether Congress has the power to regulate abortion, because as people know, your listeners know, that the Congress, unlike state governments, which kind of can do whatever they want as long as they don't violate the Bill of Rights or something like that, the federal government, the Congress, is limited to certain powers that the Constitution explicitly gives them. They can regulate commerce, they can do this and that. And the question is, does regulating abortion fall under one of those things? That's the likely challenge that would be brought in courts if anything happened. My guess is that as the kind of legal doctrines on these issues currently sit, you can make a good argument that a federal regulation on abortion in either direction can count under Congress's power to regulate interstate commerce, because that power has been interpreted to let you regulate anything that might have an impact on commerce, even in the aggregate. And so, if someone defending that law could say, well, women were going to be crossing state lines to get abortions if Congress didn't guarantee access everywhere. So this is affecting interstate commerce.
Okay, so I haven't heard that potential avenue before, because I've been trying to think of, how could they possibly challenge this? But that does seem like a viable challenge.
It'll be an issue if Congress passes it. Now, of course, once the courts say you can regulate abortion from Congress, then obviously the parties will be tempted to do that in their favorite direction whenever they get both both Congress and the White House. Of course, as things stand, they'll also need a filibuster-proof majority in the Senate. They don't have that now. I don't think they have the votes to get rid of the filibuster for the purpose of nationalizing abortion law. But
not right now.
But we'll see. Yeah, that'll be an issue down the road.
Okay, so I wanted to run this by you because I saw somebody, and I don't think that there's a lot of people making this argument, but I saw someone, she's a legal analyst for, I think, either NBC or CBS, same thing. But she suggested mounting a challenge against abortion restriction under the First Amendment, like specifically the freedom of religion. Basically, because not all religions believe that life begins at conception. So she was suggesting that they could challenge it on those grounds, that somebody who doesn't believe that religiously should be able to get an abortion. How effective do you think that would be? Or is that even like a viable method?
Yeah, so it depends. So there's a lot there. So one thing is, it's not enough to say my religion allows abortion, therefore you've burdened my religion by forbidding it. You'd have to say my religion requires abortion, or at least that requires me to get one, or at least that my religion puts pressure on me to get one, that there's special religious value in getting one rather than not. So that's one hurdle to clear. It's not obvious that there are religions that say that. A second thing is that even if you show that, say, all right, there's a burden on my religion, under the statutory and constitutional protections for religion, even however broadly you construe them, they require a step 2, which is, does the state have a compelling interest in restricting you in this way anyway, even though it burdens your religion? And I think then, the states will argue, well, yeah, there may be a burden on your religion if your religion requires you to get an abortion or favors your getting an abortion. But we have a compelling interest in enforcing this law anyway, which is protecting fetal life.
Okay. That's kind of what I imagine too. Maybe not in those terms, but I mean, obviously, like say, if my religion requires me to shoot people wearing yellow shirts, it's probably not going to hold up.
Right. Yeah. There's definitely compelling interest in forbidding
rights.
that.
Yeah, exactly. Okay, okay, that's interesting because I've been wanting an answer to that question from somebody like yourself. So I'm glad because it didn't seem like a very smart move, but I don't have the knowledge that you have to know why it doesn't. So yeah.
Yeah, I think what you're seeing is that there's just lots of pressure for people now that Roe's on the chopping blocks to find another avenue to guaranteeing abortion access, and I think that's one example of that.
Yeah, I imagine that we'll be seeing a lot more of these types of ideas
yes.
Coming up. So I want to pivot a little bit. I want to talk about guns and gun laws. And I'm sure you heard about that shooting in Buffalo, New York. And New York has some of the strictest gun control laws, right? Especially when it comes to their licensing scheme, as far as obtaining a concealed carry permit. And it's in New York, it's almost impossible. Like you almost have to have different kinds of connections or have like a really compelling reason because New York is a may issue state. And I'm just going to explain for my listeners. Some states are may issue states, which means that they might issue you a permit if you go through all the hoops. But it's really up to the discretion of the official who has been granted the authority to issue that permit. So they can deny you for whatever reason, like if they don't like the color shoes you're wearing or if they think you're crazy, they don't have to give you the license. But in states like Texas or Florida, these are shall issue states. So if you go through all the appropriate steps, when you're done, they issue you the license. They have to give it to you. So this is what's being challenged in the New York Rifle and Pistol Association versus Bruin, which has been before the Supreme Court. They're going to issue their ruling. And it's basically the plaintiff is arguing against New York's gun licensing scheme, which is may issue. So if, let's say, the Supreme Court rules in favor of the New York Rifle and Pistol Association, how will this impact the landscape nationally as far as gun licensing?
Yeah, good question. So there's a couple things. In a way, the case is a little narrower than it's been billed. So the court in 2008 said that there's an individual right under the Second Amendment to own a handgun. So that's the keep part of keep and bear arms. Like you can have a handgun at home for self-defense. It has never explicitly held in a case that really focused on this issue that there's also a constitutional right to carry. I mean, that first case did talk about that because it was interpreting the whole clause, keep and bear arms, and bear obviously means carry. But this is a case that's supposed to spell out a little bit about what that means. And in particular, the New York law, like laws in some other states, require you, they don't just say that you're not necessarily entitled to carry if you're a law-abiding citizen, just because you're a law-abiding citizen. They say that you need a special reason to carry. So if you just have if you just face the average level of risk of someone harming you, then you're not going to get a license to carry. You need to show that you have a heightened risk, that you have special reasons to carry, more than average. And what a lot of observers expect, and I'm expecting this just based on the oral argument, though you never know and we'll see, is that the court will say you don't have to have a very special reason to carry. That making you have a special reason to carry violates your right, which is a general right for the average law-abiding citizen to keep and bear arms. So I think that will just mean that in those states, I think New Jersey is another one, Massachusetts might be, there might be others, where they have this, you got to have a special reason rule, that rule is going to go away. So now the question will just be, are you a law-abiding citizen? Have you gone through whatever, training or other tests that we're requiring of people to get a license? But you can't have further requirements beyond that.
Okay, so that's interesting. So the plaintiff is specifically attacking that special requirement, like you have to be like a security guard.
It's also, I mean, the issue you talk about is also implicated. I mean, the question of how much discretion an official has to decide, I'm not going to give it to you. This case, if it comes out the way that most people expect from oral argument, it will take away some of that discretion. They'll say, no, you can impose reasonable restrictions. Like, the person has to have good vision. They have to be law-abiding. They can't have a felony on their record. Maybe even more specific things, like they need to go through 2 days of training or whatever. But once they satisfy those general criteria, you don't have the discretion to deny it to them just because they don't have a special need.
So would this, in essence, get rid of may issue states, or that may issue clause, or whatever you want to call it?
Yeah, it's hard to say, because there's a couple ways they could write the opinion, more and less aggressive on that point. But I think definitely it'll significantly restrict the discretion that officials have. Now, whether there's still some set of criteria for getting a license that this case will allow states to go on enforcing on a kind of discretionary basis, we'll just have to see the opinion to tell.
I see. Okay. So now here's my other question. I've been wondering about this. So for states like New York who want to restrict firearms, New Jersey, California, others, if this ruling does go in favor of the plaintiff, what are some ways that they might try to get around it, like in how they handle their licensing schemes?
Yeah, that's a good question. So I don't know all the tricks that they have at their disposal, but I suspect they will try to ramp up the general requirements. So, there's some states, so the ones I talked about, the background checks, the just all the hoops you have to jump through. They might add further training that's required. They might require, so some states like Illinois requires a firearm owner ID card. So you have to go in and get a card, you have to apply. That takes some time. You might not go through the whole process. You might forget, you might not stop caring after a while. Those kinds of extra hurdles that are general, that like in principle you could clear if you were dogged about it, are the ones that I expect would ramp up, just in the hope that means fewer people end up getting a license in the end.
Yeah, that's what I was thinking too. I mean, in Texas, when I got mine, I had to go through a process, but it wasn't that big of a deal. I had to apply, I had to take a class online, I had to do like a shooting test. And then after that, I pretty much got it. I mean, as far as expense was concerned, it wasn't too expensive, but I could imagine that, say like New York would just place extra obstacles. You got to run 5 marathons before you can get to the class, and you got to get all these different types of clothes or whatever. Yeah. And then you have to pay all this money. I mean, and I can imagine them doing that, because a lot of them already do it, like in DC, like it's very expensive. And I don't know if you've looked into this at all, but to me, it's like when I think about, how they always talk about like systemic racism, or like the racism of gun control laws. I think a lot of gun control laws very much do have racist outcomes, especially when they add on these cost prohibitive measures. So do you think that this could even contribute to that disparity, where it becomes harder for Black Americans, Hispanic Americans to obtain concealed carry, especially when they tend to be the ones who need them the most, depending on where they live?
Yeah, I think that could be. I mean, especially if the kinds of restrictions in place make it harder for people who have less flexibility with work schedules, who aren't necessarily working from home all the time and have the flexibility to just drive out and do something like that. Mm-hmm. So I think that's a real possibility. And I think the states that we're talking about here are just states that want to just reduce the number of guns in circulation by any means. And so they might not be attentive to those kind of uneven burdens that the laws have.
Yeah, they usually aren't. But yeah, I think that's it for right now. But I mean, I really think this is interesting, and I would like to maybe have another conversation as some of these decisions come down, because this is very interesting stuff. There's some landmark cases here. But before we sign off, why don't you tell everybody where they can find you?
Sure. I'm on Twitter, for better or worse. Just dove into that deep end. And
careful.
Yeah, I know. My handle is just my first and last name, which is visible on the screen there. That's it so far.
Okay, great. Well, hopefully, but by the next time we talk, you'll be like a total full-on social media influencer.
Yeah, we'll see. Yeah,
all the glitz and glamour.
Seems likely.
Well, thanks for joining me. We'll have to do it again soon sometime.
Thank you.
Yes, and for you, Don't forget to head on over to libertynation.com, a proud sponsor of A Fresh Perspective. You can sign up for the daily briefing, or you can subscribe to the member zone. You can read all of the latest cutting edge conservatarian news and analysis with none of the spin and all of the nuance. So definitely head on over to libertynation.com, read my stuff, read my colleagues, read it all. Watch the videos. Excellent analysis without all those superficial talking points. Again, at libertynation.com, where truth is making a comeback.